Well, might as well get started. So let's say it's 7 o'clock. Joe, can you do minutes for tonight? Should be brief. We don't have any minutes from the last meeting to review, but we have to make an effort. We've been told by Danielle that we don't have any minutes since June, so the planning board needs to get all the minutes in for July and August. I have one meeting in August I'll get in that I did already done and approved. I just haven't sent them to Danielle, but I'll have to contact David and catch up on his. So the only thing on the agenda tonight is Firefly Ridge subdivision. And, last meeting we talked about, looking for a signed dated copy of the Firefly subdivision site plan and any information, whether the 80 acres that Bill Harris and Standish, had as part of the original subdivision, and, Wes, you said the subdivision was created in 2002. The topic was the development of the 84.6 acre lot, and does the 5-year rule apply to subdivisions? So, for a change, we have some fairly clear answers. Bob, as you know, sent a question to Danielle. Danielle, rather than sending it to the town attorney, I guess to save some money, sent it to MMA legal counsel. And looks like they did a nice job with it. Suzanne Pilgrim, ESQ, Director of the Legal Services Department, responded. I think a number of you have seen this, but I will read what she said. Danielle, as you know, each subdivision situation is unique. Each will need to be reviewed based on the specific circumstances involved. Also, I would note that landowners need to consult their own attorneys for advice as to what they may or may not do with their land. Neither the MMA nor the town is able to provide legal advice to private landowners. So that's the boilerplate, mea culpa. Generally, I can say that all contiguous land in the same ownership is legally part of subdivision, including land that the landowner retains. And then she gives us a reference, C. Town of North Yarmouth versus Woolton, 1998 and 96. It is also the case that 30-A MRS 44061E, the state statute, prohibits the original developer of the subdivision from any developing the subdivision and transferring lots in any manner differently than shown on the plan at any time, even after 5 years has passed. So, the original developer must always come to the planning board for review when dividing a lot or changing the development of subdivision, regardless of the time that has elapsed since the original subdivision approval. My interpretation of that is that the 5-year rule does not apply, and that the developer needs to come before the planning board if they're doing more building in the subdivision for lots that were not originally approved, in the last subdivision plan. So that was, a fairly clear, set of, advice, which was nice to get. And, I have to compliment the secretary of the planning board in, July of 2002, because there were two files for the Firefly subdivision right in the filing cabinet. Very nice, record making. And here is the original, site plan, June 27th, 2002, signed by none other than Josiah Pierce, who at that point, I guess, you were fresh out of high school. Right. Carl Roney, Bob Jewett, and Gordon Milliken. And this shows, anybody can take a look at it, that in 2002, there was approved Lot 1, Lot 2, Lot 3, Lot 4, Lot 5, and Lot 6, and that Lot 7 was the remaining land of Paris at 85.79 acres. So, that indicates that the 80-some acres that we were looking at was part of the original subdivision. It was Lot 7. What was the date on that? That was July 2nd, 2002. And that is actually recorded in the Cumberland Registry of Deeds at 14H13N, well, recorded in Plan Book 202, page 438, owned by William and Nancy Harris. And it gets even better. This was fun, finding this stuff. In 2006, the Harrises wanted to do some more development. And they hired Teradyne Consultants. This was September 12, 2006. And John Whitten from Teradyne Consultants sent this to the planning board, planning staff. On behalf of the applicants, William and Nancy Harris, we're pleased to submit this request for a pre-application meeting regarding the proposed expansion of the existing Firefly Ridge residential subdivision off Old Trail Road in Baldwin, Maine. The applicants are proposing to construct a roadway and develop 7 new residential lots along the property's Saco River frontage. I don't think that this is, and the area retained by the owner is shown here, and then it shows all these lots, which were in the, I guess in that original 80-some acres. What that told me was that in 2006, when they wanted to expand the subdivision and do some new building, that they came before the planning board. Now, what that brings us to is that, if the building that's happening now is not original 6 lots, or one of the, from 2002, or one of the 7 lots from 2006, then they would need to come before the planning board for, yeah.
There was no, they never followed through on this.
Okay, so they never finished it.
They never finished it.
It was never approved.
It was never approved, they never followed through.
Okay. Well, then, anything done in that 85 acres needs to come before the planning board. Yes.
I pulled out the files to take document you got, there was a check on it, 2006, it never cashed for the application. So I don't think it ever went before the thing.
My God, we agree.
Do we have the records? Okay, so, I would say that, the finding, on this discussion is that what I would suggest, let's see if everybody is in concert with this, is that, William and Nancy Harris need to, come back to the planning board with Paradigm Consultants or whomever and finish up the expansion of the Firefly Ridge subdivision that they had started back in 2006 in order for any of those new lots in the 85.69 acres to be developed. Which is what we were trying to get to, right? I mean, what needed to happen.
Yeah, they had made some.
Yes, it would. Oh, and this is really cool too. I don't know if I have it in here. No, that's the problem with it. Well, I'll just remember it. I went into the subdivision ordinance, and it gives us perfect direction for what to do in either section 9 or 10. It tells you if somebody wants to add to a subdivision or make any changes to it, you go right back to the major subdivision preliminary approval sections and go through them. So even the subdivision ordinance is very clear on what needs to happen and what our process is.
I have a couple of questions just for my curiosity because I want to talk. So somebody could build one house on the remaining 85.79 acres, even though we didn't approve a house envelope there, which we did on the other lots. Here's a question. I guess I don't know how to put it as a question. That was question number 1. And number 2 question is who owns the Riley Interval Road?
Who owns what?
Riley Interval Road. Is that a town-owned right-of-way? Or is that private?
I don't understand which road it is. David, right, I think. Red Lane, Red House Lane?
No. Through this subdivision, there runs a road. It's called Riley Interval Road. I don't know. I thought it was a public road.
That's a private way, or it's just private way right
But that
there?
was because he felt like putting it there. That doesn't mean anything.
Yeah.
Is it a town right of way? Is it a public right of way? I mean, that is something, that's a question, if they do come back to us, that's a question that will be a burning question. He and I, Joey Harris and I did some community back and forth, and I gave up my rights to the Riley Indigo Road. And I felt that was cheap because I didn't believe I had any. And he gave me a right of way off the end of Firefly Lane. And I own the piece to the east of this development. But I had always been under the impression that that was a town, had at one time been a town.
It's interesting, Joe, this private way is here, but it's not on this one that they submitted in 2006 when they added 7 lots.
I won't worry about it.
So, in answer to your first question, well, you know, I don't know if it's an answer, but what it looks like is that what was approved was 7 lots.
Okay.
So, you know, if somebody was going to build a house on lot 7, and the house was sold 85.79 acres to somebody to build a house on it, that's covered in this plan. But if they broke off a piece or 2 pieces of this and sold it to somebody who's going to build a house on it, that's not in this plan.
Well, a further piece of information about the Riley Indigo Road. The Ricky Day who lives on Pigeon Brook Road owns a camp, and that's his access. You know, I'm just saying this is going to be a kerfuffle if Joey Harris comes in to do.
That's a power line, central main power easement.
That, yes.
Okay. So, I always kind of want to get into our minutes what the outcome, the next steps are going to be. So, that really, I guess, goes to you, Wes, right?
I think I should contact the Harris, you can bring up the date what's going on, and invite them into, planning board review, see where we go with it.
Yeah. Okay.
I didn't have that.
I forgot. I was supposed to announce that anybody who wears hearing aids has to bring them to the planning board meeting and have them turned on and turned up.
I have them cranked up as far as I can go, but it's difficult without reading lips, and he doesn't hear any better than I do. But what he just said to you,
Yeah.
and then he looked to me,
Yeah.
he
He said, his next step would be to contact Harris and ask them to come before the planning board and explain what's going on and,
perfectly fine.
determine next steps. Yeah.
To go back to why I brought this up initially was not because I thought that the subdivision had to be resubmitted or amended, but that I was being, our neighborhood, our subdivision, the road leading through it that we maintain. This is not the question came up whether it's a private road or a public road or a town right of way.
Is that Firefly Lane?
Yes. But the people that own the 5 lots maintain that road.
Yes.
We do not have a homeowners association, but recently, we have seen or talked to somebody who allegedly bought a lot over, beside Joe's right of way, going through the power lines. There is the right of way from Billy Harris, and that's fine. But the person that we were talking to had allegedly bought 3.5 acres and was using that right of way to get over to the lot before he built the road in from the river road to build his property. My concern is, if we're selling lots up there and they're using our private road to access Billy's right of way, then I have concerns because they're doing it with ATVs and it bothers me. And so I brought up the question is, if somebody had bought the whole shebang and they wanted, that right of way stops really at the power line, it gets you to the power line. There's nothing between the power line and Firefly Drive that's buildable. It's all on the other side of the power line right of way.
Yeah,
And
which is it. So basically, you're saying that some piece of lot 7, some piece of that 85.79 acres, purportedly 3.5 acres has been sold off and is being built.
That's what the gentleman told my wife. There's also a question, a road that's been built on the other side of the right power lines with a structure that appeared 3 or 4 years ago. I have no idea whether these transfers are in town. They should be, if these sales were reported. But I'm protecting our privacy on that road from a lot of unneeded or undesired traffic.
Curious, you said 5 lots maintain Firefly Lane, so I guess lot 6 that was sold in September of 1997 on the other side of Pigeon Brook is not part of that group that.
No, that was, Bob Vogel built that, on that lot back in, as you said.
Bob and Melissa Vogel. But it's in the other direction, behind lots 4 and 5, across the power easement that this new.
The only thing that's on the other side of the tower is, the remaining 60 or 70 acres.
So you're saying that, the building that's taking place is going on in here?
Yes. 1, 2, 3, 4, 5. The right of way that he has leading over to 1-7 is off here. Joe's right of way is here. What I'm concerned about is RV traffic or whatever using this to get over to a 3.5 acre allegedly purchase.
Yeah, and then I guess what's interesting is that if you look at what they were planning in 2006.
Yeah, I've never seen this one.
In 2006, where you say they're building, I mean, this was.
Well, I have no idea where in this is.
Oh, see, here's Firefly Lane.
Yeah.
And this is Piers lots 4 and 5. he's calling the existing lot, they changed the numbers.
So where's the new structure going in now?
I don't, I
So this was 1, 2, and 3, and that's 1, 2, and 3. And now this was 4 and 5, but now they're calling it,
well, this lot has been sold, that's Eugene Bliss is on this lot.
so
Well, wait a minute, no.
the interesting thing is that when you look at this, 1, 2, 3, 4, 5, 1, 2, 3, 4, 5,
Yeah.
right? They added, in 2006, they added a lot 6.
So you had one over here, that became part of this owner owns this one right here, that's right here.
See, that's not on this 2006 one that was never completed, and it's not on what they're legally working off of.
Yeah, there appears to be a road through here, a structure up in here, and the gentleman that we talked with, built a lot over here.
It'll show, I just explain a little bit around this, what's happening. I think the fellow who bought some land down here, his last name is Blias, B-L-I-A-S. And, Harris is holding the mortgage, so he's paying Harris money for this. I don't know if it's 8 or 12 acres right here that he's purchased. It's been surveyed out. And I looked at the deed, and it does mention the right of way from us here, and out straight down to this land.
Yeah, see, I was thinking that, maybe, they were just continuing with this 2006 plan, but I don't see, that doesn't sound like, this is completely different.
Looking, there was a road now that goes up here with a structure. And gentlemen, this is the right of way over to this lot, and he has somewhere in here, I have no idea where, has purchased 3.5 acres.
How many?
3.5, that's what he said.
I'm under the impression somewhere around 8 to 12 acres.
Well,
and
regardless.
like almost like a full acre there.
And that's, I don't have a problem with any of that, except that it's
Yeah, it's a reason it's not on the town map yet.
But I think that if this guy bought some lot over there, that's also a change in the subdivision.
I believe this is his son.
Yeah.
The Stu
Yes.
and Debbie Reynolds.
Yes.
And the road you're saying over here is probably actually a driveway going to this part of their lane. Yeah.
Obviously there's been some land transfers going on.
When you say land transfer, was never the deeds transferred, were they recorded deeds, or are there recorded deeds on these transfers?
I'll look it up in registry view.
So that you have recorded deeds, and you know where we're talking about.
Yeah, when a person comes out to have a house built, I ask for a deed to they can prove that they own the land. And occasionally I do too, if I don't need it, but this one I make sure that the mentioned, the covenant.
And that the covenant required for actual, for a building.
But my point is, if it's sold, it should be a deed, it should be recorded.
That's correct.
That's what we'd like to
What I'm
see.
saying is that Wes would not necessarily have any knowledge of it until somebody walks in for a building permit.
Right.
And at that point, we go back and look at the deed.
But I mean, as we go forward,
Yes.
if we saw the deeds, we know exactly what we're doing.
Yeah.
Okay, I am gonna put these, files back in the, cabinet in the, CEO planning board room, so that's where they will be. And, now it's just a question of getting the Harrisons, in here, or West, let me know how that goes, and we'll get them on the, agenda.
Yeah, I'll contact them and, know how it goes, what the conversation goes, and invite them in, and, coordinate with you what date they should come in. Unless you want just the next meeting or something.
It's better to coordinate it so we can get them on the agenda. Actually, we don't have anything else on the agenda. Oh, I did add one thing. I asked Danielle that I had one thing in. And that is, the BADA, sent us, what's called the LFC-SGO, which is the Local Food and Community Self-Governance Ordinance of 2021. And, we have copies of Sebago, Hiram, and Brownfield. And the Brownfield version is actually pretty interesting because they did a good FAQ section up front to what it's about. And, does the town incur any liability by adopting LFC-SGO? No, it's immune under the Maine Claims Court Act. Are there any costs incurred by a town with an ordinance? No. Now that Maine has a food sovereignty law, is it really necessary to adopt a municipal food ordinance? They said yes. The Maine Food Sovereignty Act, MFSA, states that municipalities may adopt ordinances regarding direct producer to consumer transactions, and the state shall recognize such ordinances by not enforcing those state food laws with respect to those direct producer to consumer transactions that are governed by the ordinance. So,
Just the poultry.
okay.
Poultry is not included.
Right. You can have the license to sell.
No, but most everything else like vegetables and baked goods and stuff.
This gives the town the opportunity to decide for itself what kind of local food system it wants to, and blah, blah, blah. Anyway, and then it goes on, really interesting, who created the ordinance and where's the information. Bob, when you originally sent this stuff to me, I thought it was something that, it's food, it's going to be something that we have to add to the land use ordinance. But in reading this, it's not really, it doesn't have anything to do with land use or subdivisions or any of the ordinances that the planning board deals with. It seems like it is more of a transaction-based ordinance, for a set of rules between food producers, direct to consumers, to carve out space and make those people immune from any state control of those particular transactions. So I guess my question is
Are you on the board to use it or to deal with it?
yes. It seemed that something on a transactional nature would be more the selectmen, but
I have a suggestion. I think this would be a wonderful thing to get the 25 signatures on. Whoever brought this to you.
It was a Dan Davis, who has, I think he's from Porter, maybe. And if you look at all these ordinances, they're all just cut and paste the same thing over and over again.
yeah.
And I understand why they're doing it, you know, it just gives people freedom to, sell stuff to each other at yard sales and whatever. Without falling afoul of.
Started with big companies, Monsanto was one of them. You know, that it was trying to dictate who they could buy seeds from, and who they could sell that stuff to, and that's where a lot of stuff started.
I mean, you know, personally, I don't wanna spend the time if Joni doesn't care, somebody who's producing. You know, I mean, show me some names on this petition of 25 people, you know, Jeff Daniel,
I
you
haven't
know.
really thought about it, but, yeah, it is something that's nothing can, handle. And, I mean, I'm neither for nor against the thing, but
Yeah.
it seems like something useful for people who are doing that. I don't know how many people in town are doing it.
Yeah, I mean,
If anybody.
I want somebody to convince me before I vote for something. You know, I want somebody in town to tell me they care about it.
Yeah.
Well, you know, you've got brownfields ordinance, I use them as an example. Look what the Mennonites have done to brownfield.
Oh, yeah.
I mean, they got a 150-acre field where they grow cucumbers, squash, corn, and they're selling their own market.
Yeah.
You know, and plus they got the bakery.
Yeah.
So that's a big thing in brownfield.
Yeah.
This is probably a Mennonite town.
It used to be a big thing here.
What I see that, it's drawn a very definite line between restaurants where they prepare food and give it to customers as opposed to the farmer agricultural selling the product to a person who comes to buy it. The two examples I come up with, there's three actually now. Martin Reinhardt is the strawberries. That lady Patrick figure was down by the river is a vegetable stand. And there's a new vegetable stand up on Douglas Hill Road up by Grafton Road. They have gardens and they're selling directly to consumers. So to avail of protection of that simple transaction of unprepared food going from a producer to a consumer. They've also included that not to have meat and poultry products, because that's more FDA control. So it's a avail of protection from a more simple little transaction.
Well said, thank you. For everybody's interest, the Brownfield ordinance says this is a copy of the proposed ordinance. Hiram says it's a public hearing copy from August 19th, 2021, so apparently Hiram had a public hearing on this. And Sebago's, the copy of Sebago's was adopted on May 14th, 2019, and it's attested by their town clerk. So they must have voted on this at their town meeting in 2019 and then adopted it, which means that it's probably already out of sync with the new, what is it called?
They all look exactly the same thing.
What's that?
They all look exactly the same, I think.
Well, I don't know what Spanish has, but a prime example is Pinewood Farm down in Sioux Falls. They grow a massive crop and sell it to consumers. Not what I'm trying to do.
Okay, so since it was on our agenda, the action item on that is that, we had a good discussion on it, and, it's something that the, selectmen will, follow through with. But if anything comes up, Bob, where, you wanna use a planning board for, any kind of discussion on it or anything, we can do that. By the way, I pulled up the subdivision ordinance, and it's pretty clear. It looks like on page 32, Article 9, revision to approved plans. 9.1, the procedure. An applicant for a revision to a previously approved plan shall, at least 10 days prior to a scheduled meeting of the board, request to be placed on the board's agenda. So 10 days notice. If the revision of additional lots or dwelling units, the procedures for preliminary plan approval shall be followed. So we go right back to Article 8, which is, you know, a major subdivision. And, we need to make and then submission to the applicant shall submit a copy of the approved plan as well as 3 copies, blah, blah, blah. But, since this is a major subdivision, pretty early on in the process, it should be, all applications for final plan major subdivision to be accompanied by an application fee of $300 per lot, blah, blah, blah. I think the big numbers are only if we go through hiring the independent consulting firm. So we probably shouldn't have to worry about that. But there are some fees besides that the whole non-gaming.
So, Matt,
Yes.
I think the first part you read goes back to my question about whether you could put a dwelling unit on the remainder of the mother lot, and it said, or dwelling unit, not, so just, no, you can't put another dwelling unit in there. That's what I heard, so I just want to check.
Yeah. If the revision involves the creation of additional lots or dwelling units.
Yeah.
So it's either or.
Yep. So no dwelling
It
unit,
means they have to come back.
if they put a new dwelling, and it wasn't in the subdivision.
Right.
Yep, okay, just checking.
Okay. We did hear from, a fellow and his lawyer that want to, I guess, rekindle an existing, medical cannabis production, facility. Ryan Hannon and his lawyer Mark Dion at 13 School Street in East Baldwin, and I wrote back to them and said that their first stop needs to be west, and that I gave them kind of a summary of what's in the medical cannabis registered dispensary in the town of Baldwin, but that could be moot if there's an existing CUP for medical marijuana production on that property. So I guess that's one of the things we need to look into our files and see if we get a CUP for medical marijuana at 17 School Street.
We did. I recall they came to coach me as a planning board to grow marijuana. We didn't have marijuana ordinance then. But I didn't know that that's agriculture. Anybody can grow plants, agriculture. They did get a permit for me to renovate inside the barn, roofs to close off certain plants and heat it and light it and so on and so forth. But I don't know what the status of that. I did swing by once maybe a half year after it started and saw progress on that project. It's been 4 or 5 years since then. I don't have a clue if they ever got it in production.
Did they ask for a dispensary or just a production facility?
I believe it said, production facility. Establishing a medical marijuana cultivation site at the School Street property. He resides at that address, but the property also but in the meantime, we should try and locate that, CUP.
I think they're both the one that cultivate a family, all the agricultural, but they're gonna cultivate it, they've gotta do some, distribute it themselves, so that comes from transport, so.
Well, if they do it, that's, I mean, you know, let somebody else do this.
I don't believe there was a CUP, because I remember there was a big discussion about it.
Yeah.
I remember there was a petition that came before the selectmen.
Well, I will look through the CUP file and see what I can find.
And normally it's agriculture, we don't.
We'll get as lucky as we did with that. Okay.
And actually, the law that changes so rapidly, I haven't bothered even to try to keep up with it, can't.
Right. Yeah, and Bob is working with even Sumner, you know, but nothing has been forthcoming to what the state is, saying they're gonna change.
I'm not working with him anymore. I did when I was on the planning board for a short period. But he intimated that he was an advisor to somebody working at the state level, revising marijuana laws, and that there was something imminently coming. And the last communication I had from him was still put it off until it changes.
He did write me an email saying he had been working with you and introduced himself, so I can dig that email up and,
But I'm not doing anything with him anymore, but,
I'll follow up with him. So I'm gonna do two things. I'll follow up with even Sumner, I'll look for the CUP, and if there is nothing with even Sumner, we can ask, Danielle to, not right now, but in the future, we could ask Danielle to contact MMA and see if they have an information stream on, updating
I know what they do, we just got a thing on email about, you know, those schools that you can attend. There's one about marijuana, about their children. You guys, you know who Mark Veronica Gunn is?
Yeah.
Yeah. Well, used to be Cumberland County Sheriff. Now I don't know, is he still represented for Portland? In Augusta?
I think he is, yeah.
Yeah.
Yeah, this Mark Dion is part of Fredette Dion LLC, 155 Gray Road, Valley, Indiana.
He's on the Portland, council. He is on the Portland council.
I know he was still in politics. Yeah, once they get in.
Well, you know, his first neighbors. He was on that south of the Portland stuff, went down into the hill from the Austin Catholic Hospital. He was on Portland Police Force then. And then he worked his way up into Chitwood. Then he couldn't get any higher, so he went to work in Cumberland County.
Nope.
CEO update, Wes, anything, coming down the pipe that we need to start thinking
No,
about?
nothing directly towards the planning board, but, just out of curiosity, to keep you informed, I've given 2 visits to our solar farm, on River Road, and they've got a lot of trees cut down. I've seen some forestry machinery that I've never seen before. It's all mechanized.
Yeah, here that,
We will look
the
on that.
hills comes right up, over the pond, I figured that's what it was. So they're just doing the clearing now.
Yeah. So, moving along, I guess. The other one is,
So I'm gonna have to look forward to, right next door.
let's work on 79 Pigeon Brook. I think they're on hold. I had a letter cleared by the Selectmen Tuesday, was gonna hand deliver it, I went there Wednesday, nobody was there, and I went there this afternoon.
Was that trailer?
Yeah, the trailer had to move closer to the road, like it gets ready to ditch it and fall away.
Yes, because you delivered them, back in July, this is saying they had to.
Yeah, I started back in early July, I think, with a complaint from a neighbor, so that got my curiosity, so I started inquiring and talked to Miriam Davis and her son Richard, who own the property. And, it's clearly the people in the trailer are taking advantage of overstaying their welcome. So, and the 7-month time limit is being estimated, you guys, we got there probably with January, February, the 7 months was up at the end of August, so it's time to push tricks to shove to get them up. So I'm still gonna deliver the letter that they weren't around, but I talked to him last Sunday, he says I'm making plans to move this week, so he's coming through.
Good, yeah, I talked to, Suzette, I talked with, regularly, because she does the accounting services for the library. And, she has some choice words.
She's not happy.
I'll add a little bit to it.
Talk to him too.
Did you get a chance to talk? Did you get a chance to talk?
Oh, yeah, I mean, she's good.
Yeah, she is. She's good. I would tell you that the 60 acres was cleared in 2 weeks. So the 30 acres next to you should be, the noise should not go on and on when the wiring process. They just come in and do it. But, I mean,
All right. I'll have to see if I can get up the schedule while I'm at the, archery shoots.
they need to do that, yeah.
One week a month.
Yeah.
See, they get the road where they're gonna lay the tower on 113, that's all swapped out with two lanes.
Yep, that's as much road as you're gonna see, by the way. All that is a CMP, area to park their truck. When they do the attachment of the wires, or come back to do any maintenance. So it's, they gave the contract to a local board too. Steve.
To who?
Steve put it in. Steve actually put it in.
Yeah, good.
Yeah.
Anything else? Not really. Okay. No, that's current events. Love it.
Lloyd, Tom, anything?
Yeah, this Firefly Lane episode and the Grant Lane episode before that, points to a deficiency in our tracking of stuff here in town. We don't have a map that shows what land is under subdivision, control, and so I've talked to Wes about digging out as much information you can as what's in subdivisions, and it could be very small pieces, somebody divides our land into 3 pieces, that's a subdivision. Whether it looks like it's got houses on it or not, and, according to these rules, if you wanna further subdivide anytime ever in the future, you come back to the planning board, and so we need a map that shows this land is controlled by subdivision, what the subdivision is.
Would it make sense, to talk to Cumberland County Assessing? I mean, they're working with this sort of thing, and this sort of information would be of interest to them too.
I don't know that they have the information, why they necessarily would have it, but, because they're primarily concerned about putting value on a piece of land.
I didn't know if it's a service they may be offering.
Pardon?
I didn't know if it was a service they might offer.
Well, maybe, but if we could put it in an overlay on our GIS map, that would be great. But
Great idea.
we need to do the research, and, also, make sure that we have a note somewhere that the 5-year rule does not apply once it's part of the subdivision. And, hopefully in the future we can, avoid these type of issues at the point where someone comes in. I mean, you can't avoid somebody selling property that they shouldn't, but you can avoid giving them a building permit, which would send them back to the owner.
So does any help, here's, exactly what you were saying, that's the verbiage from, MMA that covers the 5 years old.
Yeah, I know.
So, should this be, the registry of deeds, do they have anything? I mean, shouldn't the deeds down there be flagged in some way?
I don't know, I'll look at a few and see. I mean, Wes had the example of his property that was subdivided, back in the 70s, somewhere like that. Yeah. And his deed said, this 10-acre piece or whatever cannot be further subdivided. Yeah. It's in the covenant on the deed, but the covenant language in the deed. But they don't necessarily have to put that in there if it's covered by our ordinance. It says it can't be subdivided. And so I don't know that there's anything obvious about it anywhere. But it's another instance where things are changing quickly in Baldwin, and we need to get our management practices up. This is nothing. This is one of the things that we can do.
I think another thing that happened is, sitting back here and listening to a lot of the stuff was 10, 12 years ago when it happened. Working with our previous assessors, some of that stuff went through their fingers. We didn't know nothing about it. So now there is a program set up, so when the deeds change, or when he gives a building permit, it goes to Dan Allen, and then it goes to Government County Assessors. So there is a check within the check plan, but it still won't tell us.
It doesn't say, oh, this is in the subdivision.
No. At least we know the deeds are transferred and stuff.
I just wonder if a conversation with Mr. Thompson might be interesting. He might at least know of other towns and what they do.
I'll send him an email, see what he knows, if they have a service, but, I think we need to get a list of all the subdivisions that have been issued and, pencil them in from now on.
You're right.
On that.
It sounds like it would be a good way, when you think about the growth ordinance, to see, well, here's Baldwin, and here's where all the subdivisions are, maybe a sense of, is the growth ordinance, adequate, or, does it need to be tweaked? Okay.
I do have something else.
Yes.
We've been talking off and on, maybe for the last 15 years, about updating the comprehensive plan. And I never did anything positive about it because I thought updating the comprehensive plan meant redoing it from scratch. But I think I'm understanding now that updating the comprehensive plan involves reading it and saying, we ought to change this sentence here and that sentence there. Send that to the town meeting as an amendment, and you have just updated the comprehensive plan. So it seems to me, Bob, you would ask me why we didn't do it. And, I think there was a feeling on a lot of people's parts, this was a monumental task. I'm now thinking of it as maybe a manageable task. I'm just throwing that out there. I don't know that I'm volunteering for anything. I'm more saying, yeah.
Reinvent that wheel, believe me.
You don't want to reinvent the wheel, and you don't have to. And it could be you look at the comprehensive plan and say, yep, we like it, and then put that in front of them. So, that's probably something that the planning board should think about. It's just,
Is our pronouncements about, the comprehensive plan the purview of the planning board or the selectmen?
Do it either way, but in fact, probably when it was first developed, it was,
Initially, the state required it, which drove us to
it was a big.
do the first plan. It was a state requirement. And if there's any way to amend that, easily, then that's certainly the way to go.
Yep.
I don't think the state has the same position on that they did at that time.
I would offer the observation that the planning board, is, doesn't have a great track record at the current time of reviewing and revising ordinances. We started on the subdivision ordinance and, we don't see, there's two work streams and the business and project and regular work stream seems to eat up all our time and, so we still have finishing the subdivision ordinance review on our plate. So if we're gonna start on the, comprehensive plan, I would say that we need to prioritize, which is, more important.
I would suggest a way forward would be to assign it to one person. And, have the one person come up with whatever's needed. And the planning board can look at that and decide they don't want to bother reading it or not, and approve it or not, and.
Well, that's not what we did with the subdivision ordinance. We have to, as a group, we have to look at what, Don, did and say whether, that's, copacetic or not.
Okay.
So, and you want to do the same thing with the, comprehensive plan?
Oh, no, that's fine. I'm fine. I'm fine.
It's just something on the evenings, look at the plan. I can't go, not just for the one.
Yeah, he said it's probably out of date.
Let's give it to, David, since he's not here.
Well, I'll put that in the minutes, to see if you read the minutes.
Right. Okay, folks. Motion to adjourn?
So move.
Second, all in favor? 8 o'clock, basically, we're adjourned.
Great.